Good morning, everyone. I hope you can hear and see us. Welcome to the latest in Cornerstone's series of property webinars. My name is Shomik Datta. I'm a property and commercial barrister, and from the register of attendees that I've seen, I think I've had the pleasure of working with a fair number of you, which means sadly you've had the corollary misfortune. Without wanting to sound like Stephen Fry, my colleague here, Victoria Osler, is also a property and public law barrister here at Cornerstone. We are part of the property team, and our practices both span the full gamut of real property litigation, and they include in particular, for our sins, a lot of and covenant disputes, including disputes relating to the right of light. As will become clear in the course of our seminar this morning, I'm very much the support act, the entree to the main course, which you will get later. But with that introduction, let there be light, the subtitle to which is essentially our aim today to shine a little light, perhaps only torchlight, on the knotty and arcane area of rights of light litigation. Next slide, please, Will. Oh, back a slide, please, Will. There we go. So I'm going to speak about, firstly, establishing a right of light, and then secondly, establishing its breach. Victoria, in part 2, will be dealing with remedies for a breach of the right of light and tips, general tips in litigation. Rest assured we'll have time at the end for a Q&A, so please do use the Q&A tab to raise any questions that you have, and we'll try and answer them as best as we can in the time available at the end. Next slide, please, Will. So we begin with establishing the rights of light and its breach. We're aware from the list of the people that we've got on our call that the numbers of interests represented are varied. So there are a number of developers, but there are also a lot of local government and general litigation lawyers. We might all find ourselves on either side of a right of light dispute. So this discussion is intentionally framed fairly broadly and not with any specific slant. But as an added bonus, and essentially in a transparent attempt to keep as many of you awake as possible, there will be, at least in my presentation, some intermittent and tenuously linked stills from movies. And feel free to take the opportunity in the chat to post the title if you recognise them as we go along. Next slide, please, Will. So let's start with some rudiments of the easement of a right to light. There is no, as we know, general right to a view from a window, nor is there any general right to sunlight per se. However, the law does permit an easement as to, quote, diffuse daylight or skylight through a window. Now that easement can arise occasionally, very occasionally, by express grant, more often by implication, i.e. under section 62, but most commonly by long use or prescription. The effect of the right is as with any other easement. So it secures a benefit for the dominant land, which has the right, over the servient land, which bears it. And practically what that means is that the use of the servient land is restricted, in particular building upon it, so as to prevent an interference with the right. The law reports over time have shown this to be especially valuable, and so a litigious area, particularly in periods of rapid development and urbanization. So you've got a deluge of cases in the 19th century, and also you've got a smattering of cases in the late 20th and early 21st century, particularly in cities. In very broad terms, what this case law demonstrates is the classic balancing act that the law of nuisance provides between, on the one hand, the right to build and the socio-economic benefits that that may bring. So that's the right to use the servient land on the one hand, and then the right to preserve basic amenity value in adjacent dominant land. As I said earlier, this easement can often arise by statutory implication, so under section 62 of the Law of Property Act 1925, and as we know, that implies into conveyances the inclusion of all rights that appertain to or repute to appertain to land that's being conveyed. So that means it can arise in circumstances where a common parcel of land is subdivided. But it is most commonly acquired and it is most commonly litigated in the context of long enjoyment or prescription. So just checking to see, we've got no takers on the quiz. The photo still is from a room with a view, the 1985 Merchant Ivory. Classic, a view that we do not have a right to. But anyway, let's get on to the rudiments of prescription. So thank you, Will. The next slide takes us to section 3 of the Prescription Act 1832, and you'll see the sections that I've highlighted in bold. So essentially, we're looking for the use of light being actually enjoyed for a full period of 20 years without interruption, whereupon it is deemed absolute and indefeasible, unless that use and enjoyment would appear to have been enjoyed by some consent or agreement. So that provision enables the creation of an easement of light through an aperture at a building if it can be shown it's been enjoyed for 20 years, ending in the date of the proceedings in question. That long use, that period, can only be interrupted within the meaning of the Act by obstruction for a year. So the practical effect is that 19 years and a day of enjoyment, actual enjoyment of light, will be sufficient to establish a right of light under section 3. Next slide, please, Will. Another way in which rights may be enjoyed by prescription and established by prescription is lost modern grant. So the difference between lost modern grant and prescription under the Act is essentially sidestepping the requirement that the 20-year period ends in the action in question. Lost modern grant relies upon indeed any period of 20 years in the past, and establishing that use as of right, and I underline those words, will enable the legal fiction of an old grant having been made. That fiction can, of course, be rebutted. That rebuttal is often if there is some bar to the right being acquired over the servient land. So ecclesiastical land can give rise to issues. The need for third-party consents can give rise to issues. And of course, in the City of London, the Custom of London can give rise to issues. The Custom of London, which is a rabbit hole which I'll avoid leaping two-footed into, but essentially provides that within the City of London, freehold owners are entitled to build upon their ancient foundations to any height. It's an interesting topic in its own, but one which we won't fully explore today. Just pausing there in case anyone is still interested, the still there of Hugh Grant, lost modern Hugh Grant, is from Glass Onion, the second Knives Out movie. Next slide, please, Will. Okay, so there are some rudimentary points that need to be underlined when we're considering whether a right has been acquired. So the first thing is as the wording of Section 3 demonstrates, the right accrues to a building, not land per se. So in order to be protected under the Act, the right of light must have been enjoyed through a defined aperture. The first thing, therefore, always to consider when you're advising on a right of light dispute is the age of the building in question, and by extension, the age of the apertures and doorways in question. And sometimes, of course, those may be new apertures and new doorways or extended apertures and doorways. All of that building history will be relevant. So a consideration of historical planning documents and historical photos is always useful. And I've mentioned there the relatively recent case of Florala Properties from 2020, because in that case, that was about buildings in Moorgate, it was notable that it was plans within historical planning statements that helped establish the existence of an easement. We've got someone entertaining this, my attempt at a quiz. It's not Psycho, I'm afraid. It's Rear Window, another Hitchcock classic. Okay, next slide, please, Will. So flowing from that point about apertures is a complication that can often arise when we're dealing with a sequence of buildings or constructions on the same land. What happens if an old building is knocked down when it's acquired a right of light, or when it's in the process of acquiring a right to light, and a new building is erected in its place? So it is arguable that the demolition of a building results in the destruction of the right to light. And that's arguable just on the basic principles relating to abandonment of easements. So if something is done which objectively indicates no intention ever to use that right of light again, and one would suggest that the demolition of a building would indicate that, then that may give rise to the end of the right to light in question. However, if there is a manifest intention to continue using these rights on the same land, i.e. by construction of a new building in place of the old building, it's settled law that the rights are not lost. And the case that I've referred to on the slide from 1880, Keno, was an unusual case in which a church was demolished, but in order to evince or demonstrate the intention to keep using the rights, a wooden structure was erected to show the location of windows that were planned in the new building that was eventually constructed. Happily, I don't think it's expected that anyone goes through that machinations these days. Most of the time, planning documents will be ample to show the intention to continue using the apertures in question. The thing then to consider, though, is how the apertures in question, the new ones, coincide with the old ones. Where there is a coincidence, let's say they're in the same spot, there will generally be a continuation of the existing rights of light, or the continuing accrual of those rights to light, and the authority for that is Tapling and Jones. But we've got the contrary position if there is no coincidence. So let's say, for the sake of example, the old building has all the apertures in the southern face flank wall, it's demolished, and a new building is constructed which has all these apertures in a northern face or an eastern face. If there is no coincidence between the old and new windows, the old right will be lost, and that's Ankerson and Connolly. This issue can often arise where land is particularly valuable, so in cities. So where you have existing buildings, office buildings, for example, in the city, demolished in order to erect much taller, higher buildings. It often gives rise to a need for us as advisors to trawl through historic planning documents and photos. And there's an example of a case in the 1930s where a claim to protect a right of light failed because there was lack of evidence of the position of the old windows. So it's always useful to have in mind the necessary collation of that evidence. So let's see, no takers on this one. This was a skyscraper. I think an execrable Dwayne "The Rock" Johnson movie from 2018. Right, next slide, please, Will. Okay, so the next thing to consider when you're in the process of establishing your right of light is to consider whether it has been interrupted. So Section 4 of the Act gives a specific meaning to interruption. So it requires an obstruction of the right and for that obstruction to be acquiesced in for a year. So this is often simply by physical obstruction, i.e. the construction of a building which blocks light. But we have also the Rights of Light Act 1959. That permits service of light obstruction notices, which have the same effect as a physical obstruction by a legal fiction. So essentially, by Section 3 of that 1959 Act, the service and registration, the registration of a right of a light obstruction notice has the effect of a fictional structure being taken to exist in the dimensions given in the notice. And so that would have the effect of creating a legal interruption if the light obstruction notice remains unchallenged for a period of a year from registration. So there are two obvious purposes for a light obstruction notice in our context, depending on the dates in question. The first is to prevent a right of light crystallizing in the first place. So this is often useful where, for example, you are developing in an area where you know the surrounding buildings were constructed less than 19 years and a day ago. The second is where you fear a right of light issue and you can use the light obstruction notice to try and extinguish at least a prescriptive easement under the Act, and also tactically to flush out any potential objections to your development. If a light obstruction notice is registered, it's essential that the dominant owner acts quickly. He has to bring a claim to vindicate his rights within a year of the date of registration. And that claim will essentially seek a declaration that his land has the right of light and that the fictional structure would injure or interfere with that right of light. And if those two things are established, the light obstruction notice will be cancelled. As a pictorial depiction of interruption, we have Girl Interrupted from 1999 with Angela Jolie. Next slide, please, Will. So I think that's gone ahead a few slides, Will. And just one back from there should be consent. Yeah, perfect, thank you. So another point to consider when you're in the throes of establishing your prescriptive easement is whether there has been a consent. Section 3 explicitly excludes enjoyment by consent from a prescriptive claim. There are often, in conveyances of land, including leases in particular, reservations by the grantor of a right to build on its or their retained land or adjacent land, or indeed an explicit reservation of rights of light from a conveyance. Whether the wording in a particular conveyance amounts to a consent under Section 3 is always a question of construction of that document in its context. So that comes from Mr. Justice Lightman in Marlborough and Wilkes. A recent leading case, which was Patton Holdings, discussed that issue in the context of a reservation of a right to rebuild within a lease. And that reservation was construed as a consent under Section 3. And what was noted, importantly, was that the function of that provision within the lease was to prevent the enjoyment of light from being deemed to be absolute and indefeasible under Section 3. That was the critical thing for the judge's concern. So it is critical then in considering historic conveyances to see if there is any reservation or provision within those conveyances that could amount to a consent. And the sort of critical way in which you can distinguish between what is a consent and what is not is essentially whether the provision is geared to framing what was being conveyed at the time and going no further than that, or limiting rights that may arise in the future. So does the conveyance address the present only, or does it have in mind its future? If the latter, it will be likely a consent. Many interesting issues can arise in relation to consent, not just whether one exists, but whether and how they may affect successors in title. I'm afraid the law isn't straightforward on that, and it would require specific legal advice to be taken. And I certainly can't cover it or do it justice on a single slide. Next slide, please, Will. So can one, having established an easement, abandon it? And the short point, I think the short response to that is probably not in most circumstances. Abandoning an easement is pretty hard. The law is relatively clear, and that says that abandonment of an easement will not be lightly implied. And the principles were enumerated in a case called Odeon Barber from 2008, which was approved more recently by in Dyer and City of Westminster. And they're essentially 5. Whether a person intends to abandon an easement is a question of fact, which will be objectively construed from all the surrounding circumstances. Abandonment depends on the intention of the dominant owner as perceived by the servient owner. The conduct necessary to demonstrate an abandonment is conduct necessary that necessarily makes clear an intention that the right will no longer be used or ever be used in the future. And just pausing there, practitioners will recognise that there's a clear overlap here between with the law of estoppel. So essentially what underpins this is a form of estoppel where one party by their conduct is essentially representing that they will no longer use this right. And often, more often than not, the servient owner will respond to that by doing something on their land at their expense, i.e. building. But the law is clear that abandonment will not lightly be inferred, and non-user of itself is not evidence. Now, that's usually more important in a right of way context than a right of light, but it does arise in a right of light context as well. Next slide, please, Will. So we have specific examples of that in a right of light context. Smith and Baxter involved boarding up of windows for a prolonged period. In that case, that was held to amount to abandonment of a right of light. Earlier, there was a contrary decision in a case called Stocko and Singers, which I've not put up on the slide. But in that case, the owner had blocked up his windows for 20 years internally with rubble, but outside the apertures remained visible, as did the iron bars protecting the window, and it was held that he hadn't abandoned his right of light. More recently, so in the 20th century, we've got Marine and General Mutual Assurance Society, and in that case, windows had been blocked, but again, like Stocko and Singers, the apertures and sills remained visible. Although the infilling of the windows was substantial and solid, the fact that that could easily be reopened and that the apertures and sills remained meant that the right hadn't been abandoned. It's a surprising decision to many, but makes clear how difficult it is to implicitly or impliedly abandon an easement. Just as an aside, it's not an abandonment case, but it's simply a prescription case. But in Tamara's Vincent Square and Fairpoint properties, a case a lot of you will have heard about in the context of discussions of percentage, negotiations of premiums and percentages of release development value. In that case, 2 windows had been permanently blocked on the inside with panelling, but glazing remained visible on the outside. In that case, it was held that act had prevented the right to light being enjoyed, and so it hadn't arisen by prescription. This picture of boarded up windows is a picture of the House from It by Stephen King. Okay, next slide, please, Will. So those are a litany of considerations in terms of establishing the right of light, but essentially we're looking at good evidence of the existence of the aperture for at least 19 years and a day, and that will generally be sufficient, subject to the pitfalls that we've looked at. The next question for us is, what happens if there is a breach, and how do we establish that? First question on is there a breach? And what we know about the law of nuisance is that generally all nuisance acts, all acts of annoyance or interference with our enjoyment of land will not necessarily be actionable. The same applies here in the context of the right of light. So there'll only be a viable claim for the right of light where the loss of light is such as to render the occupation of the building uncomfortable according to, quote, the ordinary notions of mankind, that fantastic phrase from Coles, the only House of Lords / Supreme Court right of light case. That was explained more recently, but not all that recently, in Allen and Greenwood by Lord Justice Buckley. And he said the amount of light in question is sufficient light, according to ordinary notions, for the comfortable or beneficial use of the building in question, again according to ordinary notions, for such purpose as would be constituted a normal use of the building of its particular character. So just pausing there, it's clear that the nature of the building will be relevant to the question. So the amount of light necessary may vary between commercial and residential property. The nature of the room in question may be relevant. The right of light will obviously vary as between living areas and only temporary usage areas such as bathrooms or toilets. But also the possible future layouts of buildings may also be relevant. And so we have on the slide the case of Carr Saunders and Dick McNeill, where that was confirmed. If there is a possible, and that means there is a reasonable possibility that a form of development could occur on the dominant land which would change the layout of the room being considered. That layout will also be considered in evaluating whether there has been a right of light injury. So just seeing if anyone's had a look at this. The picture of darkness here for our purposes is from Event Horizon. Okay, on to the next slide, please, Will. So how do we evaluate whether there has been an injury? You will all probably have heard of the Waldron method. It has been in existence for a long time, I think over a century now. In practice, it is the Waldron method that is adopted by surveyors and in conjunction with the 50-50 rule in order to ascertain in very general terms whether there has been a breach of a right to light. The Waldron method plots an area of room receiving adequate light before and after a development by reference to an area of the room from which, and this is a technical phrase, 0.2% of the dome of the sky is visible at tabletop level. For practical purposes, that means effectively a working plane about 85 centimeters high, at which measurements are taken in order to establish, for surveying expert opinion purposes, whether that room continues to receive adequate light. Visibility of a small proportion of the sky on that plane is seen effectively as a proxy for identifying which areas of that room remain well lit. The effect of the unofficial 50-50 rule is that if the area of the room receiving adequate light under the Waldron method exceeds 50% of that room, then there is no actionable injury suffered. But if it is less, of course, then there is. Now, this has been the subject of some discussion. That there's been a lot of academic and legal criticism of the Waldron method as a measure of a right of light injury, but it still remains the test that is essentially used in court. So Regan and Paul Properties in 2006 confirmed it was a very useful guide, which would, quote, apply in the majority of cases of infringement. And recently, a few months ago, in Cooper and Ludgate, the Bankside Lofts case, Mr. Justice Fancourt confirmed the same. And he was specifically asked to consider whether a different measure, in that case, the radiance method, measuring actual levels of luminescence, actual levels of light, should displace the Waldron method. And he said no. Essentially, the test had stood the test of time for many decades, had the support of the surveying profession, and also, therefore, had the support of certainty built over many decades of practice. This slide depicting a method is from A Dangerous Method, Keira Knightley's movie about Jung and Freud. Okay, next slide, please, Will. Question: in evaluating whether there is a right of light injury, do we give special weight to any particular types of light? So, for example, what if we have a really poorly lit room already, one that is already less than 50% well lit under the Waldron method? Now, again, this issue has been the subject of some debate amongst lawyers. On one view, that is, quote, precious light, as Gollum might have called it. That term was used by His Honour Judge Cook in a county court case called Deakins and Hookings. And essentially, it underlines the argument that where we're dealing with an already poorly lit room, essentially all light is incredibly valuable. So any loss of that light should be considered precious and therefore actionable. The other view is that, well, if you've already got a poorly lit room to begin with, can it ever be actionably injured? So there is one school of thought that says, how can you actually acquire a prescriptive easement to poor light? The issue was recently argued out in the Florala Properties case, and it established or confirmed what has been the accepted wisdom on this. In that, counsel for the servient owner argued that if a room was already poorly lit, no injury could arise from making it darker. And that was flatly rejected. What the court decided was that the test remained the standard test in nuisance, which is simply whether the use of the dominant land had been rendered less comfortable or convenient than before. So the effect is the focus on the development and the effect of the development on the amenity of the dominant land. The test, in short, remains as per Coles in 1904, whether adequate light remains. So the focus still is on what's left, not what is taken. And so the still is Gollum's beautiful face from Lord of the Rings in 2001, because of course he might call this light precious. Next slide, please. So what might happen when we're in a situation where we have established rights of light and we know whether we are the developer doing it or the dominant landowner aware that an injury may arise. What happens, what might occur in those circumstances? So as we've discussed, light obstruction notices might be considered. Those might prevent a right of light accruing, but they also might tactically flush out objections and obstructions from neighbouring areas. Essentially, it puts the dominant owner at on notice and makes them have to act. If they do act, if it is clear that they will preserve their right, you may consider then negotiated release. And this often happens and is often negotiated between surveyors. That is usually by a payment of premium, and the premium is usually based on a percentage of release development value using the root and park methodology relating to restrictive covenants, often in the region of up to 30%. It's essentially a windfall, not just compensation for the dominant landowner. An alternative, of course, is that the developer may try and use Section 203 of the Housing and Planning Act 2016 to try and effectively remove the easement. That, of course, is the statutory successor to Section 237 of the Town and Country Planning Act 1990, and the effect of Section 203 is that a development can take place on local authority land or land that could be compulsorily acquired by a local authority, regardless of any interference with an easement such as a right of light. And that occurs if, firstly, the development has planning permission, which it usually will. Secondly, if the development is on land which was acquired or vested in a local authority after the relevant date, here that's after July 2016, or it has been appropriated by that local authority to planning purposes. That will require the payment of compensation, but in a CPO context, that may well be much less than a negotiated premium for release. So these are the kinds of things that may be considered. Next slide, please, Will. I'll deal very quickly with the question of reform. The Law Comp published a consultation on reform. It was fairly far-reaching in 2013. It hasn't gotten anywhere. Our legislature has been interested in many other things, and as things stand, it looks very likely to be on the legislative agenda. So I would just park it. You have the slide there, and I'm overrunning already. The still, if anyone's interested, is from the movie Scum, to represent reform school. Okay, next slide, please, Will. Okay, so summary, very quickly, because I've overrun, for which I apologise profusely. Questions for practitioners always: identify the dates of the apertures in question and their construction, consider old planning documents and old photos, consider the issue of ancient lights, especially where a building has replaced an old one. Check whether there has been any consent preventing the running of time in old conveyances, or whether there have been any physical obstructions. Once we're satisfied the right exists, the question is whether it's breached, because not every injury to a right of light is actionable. That will inevitably require expert opinion, usually from a right of light surveyor who will use the Waldron method. It is only if that indicates an actionable injury that we then go on to consider the issue of remedy, which Victoria now will address.
Thank you. Now, when I first started to think about giving a seminar on the right to light, other than my brain being deluged by a whole host of songs which seemed to fit the topic, I don't know, Blinded by the Light, Ray of Light, Mr. Blue Sky, You Are My Sunshine, we could go on. It also brought to mind, and forgive the pretension here for a minute, those early turn of the century Monet paintings, where even near Battersea Park, you can see along the Thames factories belching out smoke. There's an ironworks, for example, and a smelting plant, and they're turning the air black and the air's acrid with smoke. Now, if you turn back another 100 years from there, so we're back in Dickens' London or Manchester or Coventry, and that's a city that will come up again a bit later, you find the same thing, but perhaps even worse, with black skies. And then for the really culturally sensitive amongst you who've watched that historical narrative, which is The Crown, you might remember that there's an episode in the 1950s when the skies are black with pollution, and that's the end of open fires in London. Why that little bit of historical narrative, other than my quest to be a podcaster on The Rest is History? It's because it gives the background to the need to preserve and the court's desire to preserve, amongst all of this darkness, some blue skies. And how the courts have sought to do that, whether it's in that rather dark picture I painted of days gone by, or in the current times where we have skyscrapers puncturing the skies all around us, and this tension that we have between the beauty of a blue sky and build baby build, is to give injunctions to stop that interference with the right to light that we're talking about today, or to award damages in lieu of those injunctions. So that's the background for what I'm going to talk about remedies, that tension, and how those are reflected in the relief which the court gives. So, Will, if I can turn to you, please, and if we can actually go on to the second slide. Thank you very much. So, in relation to remedies, assuming that there's been a breach of covenant, which is we've just heard about, and that's either express or implied, and that breach is proven, and proven that the light has been infringed, the question becomes, what we're talking about, what the remedy should be. Who can seek the remedy, first of all? Well, interference with an easement, as we know, is a type of nuisance. That's because a private nuisance is an act or an omission which is an interference with, or a disturbance or annoyance to, a person in the exercise or enjoyment of his ownership or occupation of land, or of some right used or enjoyed with the connection of that land. So just as blocking a right of way is a nuisance, so is interrupting a right to light. Now, why mention this is because, as such, it's not only the occupier of the land, the leaseholder, who has the right to bring proceedings to enforce their rights, but also someone entitled to the reversion, so the freeholder or a superior leaseholder, if the nuisance would do permanent damage to the reversion or the interest that they hold. In relation to the first form of relief that such a person might seek, injunction, as I say, is the traditional one. And what better place to start with the landscape of injunctive relief in this context than with Lord Neuberger in Coventry and Lawrence. I promised Coventry, and there it is. Who, as is characteristic of Lord Neuberger, gave an excellent historical survey of the tension between injunctive relief and damages in this context of right to light. And if I can quote him, he says this: where a claimant has established that the defendant's activities constitute a nuisance, prima facie, the remedy to which she is entitled, in addition to damages for past nuisance, is an injunction to restrain the defendant from committing such nuisance in the future. Of course, the precise form of any injunction will depend very much on the facts of the particular case. That's where we started, that urge to protect the light. So there you go. Simple. Don't need to go any further. Injunction is the relief to which the courts will turn. Not necessarily so. No, there's a bit more to talk about than that. Because it's long been the case, as far back as the Lord Cairns Act in 1858, you may have guessed I was a little bit obsessed with these Victorians, and they just keep coming up where we're dealing with this subject, that statute has permitted damages to be granted in lieu of an injunction. And the current position is set out in Section 50 of the Senior Courts Act of 1981, where the Court of Appeal or the High Court has jurisdiction to entertain an application for an injunction or specific performance. It may award damages in addition to, or in substitution for, an injunction or specific performance. And now that creates a tension and a difficult dividing line. And that problem is encapsulated in two opinions in the Coventry case. Next slide, please, Will. Here we have two differing opinions. One, Lord Mance, let's call him the Lord of Light on this occasion, and Lord Sumption, maybe the Prince of Darkness, although we know someone else has recently been associated with that title, but we won't get too political about these things. So what did Lord Mance say? He said, in relation to remedy, that the right to enjoy one's home without disturbance is one which I would believe that many, indeed most, people value for reasons largely, if not entirely, independent of money. Lord Sumption, however, put the alternative argument. There's much to be said for the view that damages are ordinarily an adequate remedy for nuisance, and that an injunction should not usually be granted in a case where it's likely that conflicting interests are engaged other than the parties' interests. If we look across the pond to a US case, Boomer and Atlantic Cement, get a useful example of the tension between those two positions to which I've just referred. In Boomer, sounds such an American case, there a nuisance had been caused to residents by the operation of a cement factory, and an application was made for an injunction to close the factory. The factory, however, had cost, and remember this is the 70s, $45 million to construct, and it employed 300 local people. Closing it, therefore, had to be balanced against the damage to the applicant's enjoyment of their properties. Now, in UK terms, the issue often arises where planning permission has been granted, and if the local authorities afforded an opportunity for objections to an application for planning control, has taken into account the concerns of a neighbouring landowner regarding the limit to their right to light, but nevertheless less balanced against those objections the public need for development, should a landowner be entitled to stop development by reliance on an easement of light? Next slide, Will, for the answer. Well, since 1895, back to my Victorians, case of Shelfer and City of London Electronic Lighting Company seemed to settle the issue. I say seem to because I say at the end, if you're going to hang on that long, we'll come to Cooper and see if it has preserved what Shelfer had to say. But just to remind us what that was about, it concerned noise and vibration from electrical generators which have been installed to residential properties in Bankside. Bankside's going to become topical again. Having accepted there was a nuisance created by the noise and vibration, a key issue became the relevance of the introduction of the power in the Law and Cairns Act, for those of you that have been paying attention, to grant damages in lieu of an injunction. Perhaps reflecting the supremacy afforded in the 19th century to land ownership, the Court of Appeal found that any person whose property rights had been violated had a prima facie right to an injunction, and while damages could be offered in lieu, that should only occur in exceptional cases. And they then gave some principles as to what those exceptional cases might be, but just pause there to note we've got 19th century authority, prima facie the rights to an injunction, and damages are so exceptional that they will only be appropriate in exceptional cases. An example, the 4 Shelfer principles of when those exceptional cases might arise is 1, the injury to the claimant's legal rights is small. 2, the injury is capable of being estimated in money. 3, the injury is one which can be compensated adequately by a small money payment. And lastly, it would be oppressive to the defendant to grant an injunction. Now, the last of those tests shouldn't be confused with a balance of convenience type test. The test is one of oppression. That was emphasised by Lord Bingham in a case which I always remember because I want to call it Jagger and Richards. It isn't. It's Jagger and Sawyer. It's a 1995 case. But again, the emphasis there was that a test is one of oppression. Now, an application of that test in the context of the right to light comes from Regan and Paul. That's a case which you heard in the previous talk. But quickly on the facts of that case. In that case, the claimant owned a mansion on the 1st and 2nd floor. The defendant was a company developing adjacent land so as to replace a 3-story building with a 5-story building. The claimant believed the new building would infringe his right to light, and he issued proceedings for an injunction to compel the work to stop. The evidence at trial, and we'll come back to evidence right at the end because it's key, was that the new building would reduce the area of the claimant's living room receiving adequate light from 67% to 42%. Now, the judge at first instance found that this was an actionable nuisance, but when it came to relief, he placed the onus on the claimant, so the party that was losing the right to light, to show that he should not be awarded damages rather than injunction. So rather than starting from the prima facie case that your injunction is your relief, the first instance judge turned it around, said the claimant had to show why damages wouldn't be an adequate remedy. Got up to the Court of Appeal. Lord Justice Mummery, not at all pleased about that approach. He found the judge was quite wrong to place the onus on the claimant and, in very unequivocal words, found the defendants must take the natural consequences of their acts in interfering with the right to light. And applying the principles set out in Shelfer, those 4 principles to which I previously referred, Mummery found that the reduction in light from 67 to 42% wasn't a small injury, and it required the claimant to rely on artificial light, God forbid, artificial light, or sit beside the window where, outrage of outrage, he could be observed from other properties. Mummery could not stomach that thought. Second, that although the injury was adequately compensated, although the injury was capable of being estimated in money, it wouldn't be adequately compensated by a small money payment. And last, it would not be oppressive to the defendant to grant the injunction, even though it would impact on the commercial viability of their developments. And what Mummery said was, on the contrary, the court would not be justified in denying him, the claimant, an injunction and effectively forcing him to accept compensation from the defendants for losing the light in respect of his home. Now, the Supreme Court in Coventry reviewed those authorities, and many, many, many others, would be here for hours if we went through them all, and identified 2 problems with the law. First, attention in the authorities as to whether exceptional circumstances, back to Shelfer, that high test, were needed before damages would be an adequate remedy. And 2, the relevance of the public interest in the exercise of the discretion to grant an injunction or award damages. The tension I talked about at the beginning, the blue skies or the bill baby bill tension. Next slide, please, Will. Lord Neuberger, and all us lawyers just love saying this to clients, and all clients hate us saying it to them, but said, well, this is a classic exercise of discretion. It shouldn't be fettered. Every case must be determined on a case-by-case basis. Insofar as guidance could be given, and this is, no, we can stick with this, Will. He gave 8 points, and I'm just going to rattle through these because I know we're running out of time. But the prima facie position is that a claimant was entitled to an injunction, so no disturbance with Shelfer there, such that the legal burden was on the defendant to demonstrate why an injunction should not be granted. The application of the tests in Shelfer should not be applied so as to fetter the court's discretion. It would normally be right to refuse an injunction if the 4 tests in Shelfer were met, but if those tests are not all satisfied, that doesn't necessarily mean that an injunction should be granted. An injunction may be necessary where the injury can't be compensated, or, and the courts don't like this at all, if the defendants acted in a high-handed manner, such as tried to steal a march on the plaintiff to evade the jurisdiction of the court. On the other hand, if there's a next slide, please, Will. If there's really a question as to whether the obstruction is legal or not, and if the defendants acted fairly and not in an unneighbourly spirit, the court ought to incline to damages rather than to an injunction. 6th, the grant of planning permission for a particular activity may provide strong support for the contention that the activity is a benefit to the public. Seventh, the existence of planning permission which expressly or inherently authorises the nuisance can be a factor in favour of refusing an injunction and granting damages. And finally, planning permission is particularly persuasive where, and this is a quote, the planning authority has been reasonably and fairly influenced by the public benefit of the activity, and where the activity cannot be carried out without causing the nuisance complained of. So ultimately, the question comes back to the lawyer's answer of case-by-case decisions, but there does appear to be a move away from the 19th century Victorian protections. And it seems likely that, in particular, when we come to Cooper, that in the current drill, baby drill, bill, baby bill world that we're living in, that move will probably continue. Damages, I'm going to be very quick in relation to this. Damages for any tortious wrong, as we know, first day of law school here, is to far as money can to put the applicant into the position in which they'd been in but for the unlawful act. Reagan, authority we've both mentioned, the diminution in value for up to 67% loss of light to the living room was said to be 2.5% of the capital value of the property benefiting from the right to light. It should be said the potential amount of damages is frequently weighed in the balance when deciding the question of oppression. What is the cost to the person infringing the right if their development plans are reduced by way of an injunction preventing development? And in Reagan, the developer sought to lose around £200,000 in reduction in development value and the cost of restoration. But diminution value is not the only yardstick. In Coventry, the Supreme Court noted that damages might well, at least where it was appropriate, also include the loss of the claimant's ability to enforce her rights, which may often be assessed by reference to the benefit to the defendant of not suffering an injunction. That leads on very nicely to Cooper, which next slide, please. I've got another Prince of Darkness. I don't know if I'm obsessed with Mandelson or Ozzy Osbourne, but in this case, the Prince of Darkness was more likely Lord Justice Fancourt, or maybe that's what Prince Harry would consider him to be. But anyway, Cooper and Ludgate House was a Fancourt decision. It was a tale not so much in the Dickens theme of two cities, but of two flats and one office block. And it's also a legal moment because to Lord Justice Fancourt's delight, sorry, Mr. Justice, I've just promoted him, I've realised. To Mr. Justice Fancourt's delight, the court was asked to weigh whether a right of light stripped of enforceability by Parliament could still count in law. Spoiler for those of you who aren't going to be able to wait, it shouldn't. Very quickly, the claimants, Mr. Cooper, Mr. and Mrs. Powell, owned flats and Bankside lofts. Said we come back to Bankside. Their view once spanned westward onto open skies and a glorious London landscape. But as with this talk, not all good things last. Mostly they come to an end, and as did that view. Enter the darkness. Arbour, a 19-storey office tower erected by Ludgate House Limited, a part of the massive Bankside Yards development, and it's a project so vast that it stretches from Blackfriars, to the edge of the Tate Modern's cloakroom queue. We'll know the Tate Modern as well in this context because of the Fern case, but that's how extensive it is. It's completed in 2022, and Arbour, that monster of darkness, now loomed over Miss Cooper's loft, casting quite literally a shadow over it. So the claimants claimed an actual nuisance through interference with their right of light. Sort of classic remedies, injunctions first, or if you really must, I'll take some money. But the case came burdened with one of those sly, knotty little complications that gives a chance to make the law, and that was Section 203 of the Housing and Planning Act 2016, to which we previously heard. Very, very quickly, 203 allows developers to override private rights, including the right of light, so long as they've ticked the boxes which they need to tick with the local authority. I'm going to avoid going into any of that, just to concentrate on the relief aspect of that decision. It did many other things. As we know, it approved in fact, was very strongly in support of the Waldron method, amongst other matters found in that judgment. And the judgment really is an essential read. But in relation to relief, well, it was refused, an injunction. Not all relief, as we'll see, there's quite a handsome damages payout, but relief in terms of an injunction was refused because an injunction would be futile, Mr. Justice Fancourt found. Would an injunction, he asked, be an unjustified waste of resources? Would the defendant be able to secure planning permission and then rebuild Arbour with the protection of the Section 203? Yes, it would. So, because the relief is futile, the court awarded two forms of compensation. First, a measure for negotiating damages in lieu of an injunction, a sum which reflected what the claimants could reasonably have extracted to permit the interference, and a diminution in value damages for the actual reduction in the property value. The Powells pocketed £500,000 and Mr. Cooper £350,000. You might think, well, that's not bad for a block view, but I suspect it wasn't what they probably wanted. But anyway, it's quite a handsome damages reward. But that case is highly fact specific, and perhaps we shouldn't think too much that it's sanctioning an approach of not granting injunctions, that it's a seismic shift away from an injunction being the prima facie remedy. I don't think it is. Had the developer acted with deceit, or had Arbour not been so nearly complete, the scales may have tipped in the balance of injunctive relief. I don't think that Cooper should be read as a blanket refusal of injunctive relief at all. Maybe at most the court's growing willingness post Coventry or Fern, the Tate Modern case, and others, to weigh in the balance public benefit and the sanctity of the right to light, and perhaps give a little bit more weight in the public benefit scale than traditionally we've been used to. That all said, if I just go to litigation tips, which hopefully is the last slide. Early action is absolutely essential. If there's a potential risk to the right of light, don't sit on your hands. The conduct of the person infringing the right will be a relevant factor when considering whether damages are an adequate alternative to an injunction. Establishing the right will usually be a question of reliance on the lease or other conveyancing documentation that contains the covenant. Where the rights obtained by prescription, and I think this is important, there'll need to be evidence of continuing use of the right. Establishing the breach is theoretically a simple matter, but that's going to require narrative and expert evidence. Expert evidence will detail the degree of infringement and the reduction in light, and narrative evidence, and this is so important, in particular with maybe the court tilting more away from the impact of the breach on the individual towards public benefit. Narrative evidence as to the impact of the breach will be incredibly important, more probably than it's ever been. Evidence should also be focused not only on the right and the breach, but also on the balance between private rights and public benefits. Links into what I was just saying about impact evidence. And where planning permission has been granted, it's important to consider the detail of that permission, including reports to committee, discussions and objections, and what was the grant of consent made on the basis of a public benefit in the development itself. That's an important factor to look at. Obviously, expert evidence will be required of the diminution in value, both to the claimant and to the defendant. And I think I can probably round us off there, given we've already going 5 minutes over. So I apologise for that, but thank you for bearing with me.
Yes, thanks, Victoria. And the apologies are all mine because I overran massively. So I'll spare you my interminable drone, Eeyorish drone, for much longer, just to say thanks for joining us this morning. We promised time for questions. We probably don't have them now, but of course, you have our contact details on the slides. You'll be sent a recording should you want to revisit those slides of it. And if you should need to contact us or anyone in the property team at Cornerstone, please do so. We'll be happy to answer your queries. Thanks very much.